could have Miss Moss out, please. All right, the next matter before the court for consideration is 18B 1541-1, State of Georgia versus Tiffany Moss. Miss Moss is present with her new counsel, I believe. Mr. Moore, is that right?
Good morning, Your Honor. Josh Moore here on behalf of Ms. Moss and Taya DeLodge.
Good morning to both of you.
Good morning, Your Honor.
Great. First thing to attend to, you may have noticed that there are members of the press present. They filed requests to record our proceedings pursuant to Rule 22. Any objection from either side to their doing so?
None from the state, Your Honor.
No, sir.
All right. You're welcome to record. Thank you all very much. All right. The purpose of today's proceedings is to address hearings and status conferences required by Rule 41.2 of the Uniform Superior Court Rules. First objective is for the court to confirm that the defendant has appellate counsel. And I assume, based on your being present here today, that each of you will be pursuing the appeal on behalf of Ms. Moss. Is that correct?
Your Honor. Yes, sir.
Very good. Second objective of the hearing is to confirm that the transcript has been ordered. In fact, in this case, I think it's more than ordered. In fact, I believe it has been completed and has been filed of record in this court. Is that correct?
I believe it is, Judge. We haven't gone through all the pretrial proceedings, but it appears to be complete.
It appears to have been done.
Yes, Your Honor, it's complete. The state has received all of the volumes.
Third objective of the hearing pursuant to Rule 41.2 is to determine who it is holds the exhibits in the case, and I believe pursuant to a prior ruling by the court, that would be the state that retains that evidence.
That's correct. The state is in possession of the evidence, and, well, all the evidence that was admitted at trial. There were some items that were taken as part of the investigation of the case that remain at the police department, but they are under instructions not to destroy or remove or tamper with them in any way. So I can account for it if I'm required to, but I can't off the top of my head. But trial exhibits are in the possession of the district attorney's office.
Very good. And that completes everything that's required pursuant to Rule 41.2. Of course, our court reporter will make a record of this and transcribe it for the purpose of the record. Beyond what's required by Rule 41.2, of course, the court has also issued a scheduling order on the motion for new trial, with the motion for new trial tentatively scheduled for November the 15th of this year. Anything else, Mr. Porter?
Nothing from the state, Your Honor.
Anything else, Mr. Moore?
Judge, our request on behalf of Ms. Moss at this time would be to set the case down for a status pursuant to Rule 41, or at least a telephonic status conference in 180 days. And we are not, as I think I've communicated informally to the court, going to be prepared to present a motion on that timeline. And so the rule contemplates 180-day check-ins, which would be in February of next year. Ms. Moss has requested not to be produced and present for those. I know the state doesn't, I believe the state doesn't have an objection to that, so we've requested that be done pursuant to Rule 41 telephonic.
Yeah. The rule authorizes telephonic hearings from this point forward. I did this in an abundance of caution, given that it's a death penalty case, that you waive any appearance by your client in person for participation in those hearings from this point forward. Is that right, sir?
Yes, sir.
All right. Thank you. I believe that concludes our hearing. We can take Ms. Moss back.
And Judge, just for the record, will the court require any kind of a formal continuance motion, or can we set it for a status hearing in 180 days?
The status hearing is required by the rule in any event. All right. Thank you.
Thank you.